Okay, let's dive right into this explainer. Today, we're going to completely shatter a massive illusion in the corporate world. You know the one, the idea that the company always pays for everything. There's this huge misconception that the corporate veil is just this impenetrable, magical wall protecting your personal assets no matter what. Well, we're going to explore the real risks, the hidden legal landmines, and absolutely crucial, the actual legal protections for corporate administrators under Mexico's general law of commercial societies. If you sit on a board, or honestly, if you run any company down there, you really need to pay close attention to this.
Because before you step into that administrator's chair, you have to ask yourself a pretty terrifying question. Is your personal liability absolute? Think about it. If the company goes under or makes a massive regulatory error, are your personal savings, your home, the things you've worked for, are they on the line or can you actually protect yourself? It's literally the most fundamental question of corporate governance.
Fortunately, Mexican corporate law gives us some hope right out of the gate with a very powerful truth. Your liability as an administrator is not absolute. You aren't just some passive passenger tied to a sinking ship. You always have legal mechanisms to refuse certain acts or to formally object to dangerous actions. But, and this is a big but, you have to know exactly how to use these tools properly, because simply not knowing the law is definitely not going to hold up as a defense. So, to navigate all of this efficiently, here is our roadmap for today. 1. The initial weight of the role. 2. Your key daily duties. 3. The very real risks of solidary liability. 4. How to build your administrator's shield. And 5. How enforcement actions actually work. All right, starting with Section 1, El peso del cargo, or understanding that initial burden you take on. There is a stark night and day difference between regular and irregular societies, and this is a massive danger highlighted right in Article 2 of the General Law of Commercial Societies. If you act as a regular administrator for a properly constituted company, you have your standard corporate obligations. Makes sense, right? But if you act on behalf of a legally irregular society, maybe the incorporation paperwork got messed up or it's operating totally outside its legal mandate, your liability is no longer shielded by the corporation at all. It instantly becomes subsidiary, solidary, and entirely unlimited against third parties. That means if third parties get harmed, they can bypass the company and come directly after literally everything you own.
Which brings us to Section 2, Obligaciones y deberes clave, the daily legal burdens you can't ignore.
Take Article 156, for example. When it comes to conflicts of interest, the law has absolutely zero tolerance. If you ever find yourself in a situation where your personal interests clash with the company's, you cannot just sit quietly in the back of the room and abstain from voting. No way. The law strictly requires you to formally declare that conflict to the other administrators and completely remove yourself from the deliberation and the resolution. If you fail to step away, you're going to be held personally responsible for any resulting damages caused to the company. You have to actively take yourself out of the equation. And hey, your duties don't just magically disappear the second you hand in your resignation letter either. Under Article 157, your duty of confidentiality extends for a full year, 1 whole year after your employment ends. You're legally bound to keep all non-public matters, trade secrets, and internal company issues strictly confidential for 365 days after you walk out that door for the last time. Okay, moving to Section 3, Riesgos y responsabilidad solidaria. This is where things get genuinely dangerous. The absolute crucial point here is wrapping your head around this concept, responsabilidad solidaria, or solidary liability. In a lot of jurisdictions, you might hear this called joint and several liability. Basically, it means that for specific corporate failures, the law is not going to neatly divide the blame evenly among everyone on the board. A claimant doesn't have to sue 10 different people for their little 10% fraction of the mistake. Instead, they can come after you, individually, for all 100% of the damages. You can be held fully accountable, all on your own personal level. And Article 158 doesn't leave this up to interpretation. It explicitly lists 4 exact areas where you carry this intense solidary liability. First, you have to validate the reality of partner contributions, meaning the money or assets the partners claim they put into the company actually exist. Second, you must ensure any paid dividends comply with all legal statutes. Third, you're personally on the hook for the existence and maintenance of the company's accounting, control, and registry systems. And fourth, you have to execute the agreements made by the shareholder assembly to the exact letter. If the company drops the ball on any of these 4 pillars, your personal shield is completely gone. But wait, it actually gets even scarier. You also have to navigate what is essentially the ultimate legal landmine, found in Article 160. Imagine walking into a brand new job, getting settled in, and suddenly finding out your predecessor was totally cooking the books.
Under Article 160, you actually inherit the liabilities of those past administrators if you discover their irregularities and fail to formally denounce them in writing to the commissaries, the corporate overseers. If you find someone else's mess and decide to just sweep it under the rug, the law says that mess is now legally yours. And yes, you are solidarily liable for it.
Take a breath. It's time for Section 4, El Escudo del Administrador. Let's talk about how to legally protect yourself from all of this. So Article 159 is going to be your absolute best friend. It outlines a very strict two-step procedure to shield yourself from liability when the board is making a terrible decision. Step 1, you must be entirely free from fault in the matter. Step 2, and this is absolutely vital, you must speak up and formally express your disagreement right at the exact moment the act is being deliberated and resolved. You can't just silently disagree and then complain about it the next day. You have to get your no on the official record right then and there, in the room.
Plus, the law does offer some proactive safety nets. Under Article 152, corporate statutes can establish a financial guarantee. Think of it basically as a bond or an insurance policy that administrators must post to cover potential liabilities, which protects both the manager and the company. Furthermore, under Article 76, if you're a manager in a limited liability company, the General Assembly actually has the power to officially absolve you of your responsibility, but they have to pass it with a favorable vote representing 3/4 of the capital stock.
All right, finally, Section 5, Acciones de Responsabilidad. Let's look at enforcement and the actual consequences.
You really have to consider the sheer power the General Assembly holds under Articles 161 and 162. A simple resolution by the Assembly to enforce liability against you triggers your immediate removal from office. You are out. Right then, done. And based on established jurisprudence in the source materials, this legal action can target you even after you've left the company. That target on your back? It doesn't just vanish because you resigned. But, you don't just have to fear the majority. There's a really fascinating check and balance in the corporate structure here. Article 163 empowers a minority representing just 25% of the capital stock to bypass the General Assembly entirely. If the majority refuses to hold a corrupt or negligent administrator accountable, that 25% minority can actually sue you directly on behalf of the company to recover damages. So as we wrap up this explainer, I want to leave you with this thought. As you sit in that administrator's chair, surrounded by all these incredibly potent legal landmines we just talked about, ask yourself, are you actively using these legal shields today? Are you formally documenting your objections in the room? Are you auditing the actions of your predecessors the minute you take the job? Or is your personal legacy completely, 100% exposed to the actions of your company? Because right now, it's time to make sure your corporate shield is actually made of steel.